Hey there, I'm estate planning attorney Paul Rabelais, founder of the national estate planning firm, America's Estate Planning Lawyers. And in this video, I'm going to dig into what actually may happen to your IRA after you pass away, particularly if you're currently married, and with even more emphasis on if you're married and you have children from a previous marriage. Let me give you an example. Let's say Jason is 55 years old and he's married to Cynthia, who's 50. Jason has 2 adult children from his previous marriage. Cynthia has 3 kids from her previous marriage. One of the reasons Cynthia married Jason is because of the potential to provide Cynthia with some financial security. You see, Jason has a $3 million traditional IRA. Now look, it could be a $500,000 IRA or an $8 million IRA. The number doesn't actually matter. Now, in addition to Jason's $3 million IRA, Jason also has a $1 million brokerage account that is not part of the IRA. Many financial advisors refer to this account as a non-qualified account. As Jason starts to contemplate his estate planning objectives, Jason's goals are twofold. Jason wants to provide for Cynthia's financial well-being if he dies before Cynthia, which he probably will because he's a man and he's 5 years older than Cynthia. And his second goal is to make sure that after he and Cynthia die, his estate will go to his 2 adult children. He really doesn't want his estate to wind up in the hands of Cynthia's 3 children to the exclusion of his 2 children. Now, because of required minimum distribution rules that impact traditional IRAs, we have to look at, from an estate planning perspective, how the $1 million brokerage account is different from the $3 million traditional IRA. First, let's look at the $1 million brokerage account. The typical estate planning move here would be for Jason to leave that brokerage account at his death to a trust. Typically, after Jason dies, Cynthia would be the lifetime income beneficiary of the trust. She gets any interest, dividends, or rental income that the trust assets produce. And Jason's 2 children are designated as the principal beneficiaries of the trust. I'm going to get technical just for a moment here, but naming Cynthia as the lifetime income beneficiary after Jason dies allows for a Q-tip election to be made on Jason's estate tax return, which would enable the transfer to the trust to qualify for the estate tax marital deduction, excluding the $1 million asset from Jason's estate, but including it in Cynthia's estate for federal estate tax purposes. Now, with Jason leaving this $1 million brokerage account to a trust like this, it provides income to Cynthia after Jason dies, but preserves the principal for Jason's 2 children after Jason and Cynthia both die. Cynthia will not have the right or ability to leave that asset to her 3 children. However, it is possible that principal could be depleted if, after Jason dies, the trustee has the discretion to distribute principal to Cynthia for her health, education, maintenance, and support. And if Cynthia is the trustee of this trust after Jason dies, she may be liberal in exercising that discretion to make principal distributions to herself, because she may want as much of that principal to wind up going to her 3 children instead of Jason's 2 children. If one of Jason's children is the trustee or a co-trustee after Jason dies, it's more likely that principal will ultimately be preserved for Jason's children down the road. But the general concept of Jason leaving his brokerage account to a trust and naming Cynthia as the income beneficiary and Jason's 2 kids as principal beneficiaries can work well. And it's the vehicle that many married people use when they want to provide for a second spouse and children of a previous spouse. Now let's look at the issues surrounding how Jason should leave his $3 million IRA. Same goal. He wants to provide income for his wife Cynthia after he dies, but he doesn't want that IRA to wind up going to Cynthia's 3 children after Jason and Cynthia die. He wants it to be for his 2 kids. So what makes estate planning with traditional IRAs and 401ks different is that there are required minimum distribution rules that have to be taken into account when you're leaving an IRA to others or to a trust. You see, when Jason sets up his IRA account, his financial institution or his financial advisor will request that he name beneficiaries for his IRA right there on the account opening paperwork. This beneficiary designation supersedes anything Jason has in his will or living trust. The perhaps inappropriate but common designation in these circumstances is to name Cynthia as his primary beneficiary and Jason's 2 adult children as the secondary or contingent beneficiaries. At least in Jason's mind, he's thinking that setting up his beneficiary designation that way ensures that his 2 children will receive the assets after both he and Cynthia die. But that's not likely to happen. When Jason dies after having named Cynthia as his primary beneficiary, Cynthia then can put that $3 million IRA into her name and treat it as her own IRA, which is what she will do. Since she can treat it as her own, she can designate whoever she wants as beneficiaries to receive what's left of the IRA when she dies. And of course, she designates her 3 children as beneficiaries. Now, maybe after Jason dies, someone like me asks Cynthia something like, "Hey, Cynthia, I thought you and Jason had an understanding that he would name you as the 100% primary beneficiary of his IRA so that you could postpone taxable distributions until you were in your 70s, which gives the most income tax deferral. And then the 2 of you agreed that once you put that IRA in your name, you would designate Jason's 2 kids as the beneficiaries to get what's left when you die." But then Cynthia justifies her naming her 3 children to get 100% of the IRA when she dies by saying something like, "Well, that's what Jason and I originally talked about when he was alive, but now that Jason has passed away, his 2 children, they don't call me on my birthday, and they spend all of the holidays with their mother, and that hurts my feelings, so I'm going to leave it to my kids," Cynthia says. Now, maybe if Cynthia is a real sweetheart and feels a little bit guilty about how Jason's kids will never see a penny from their father's $3 million IRA, maybe she'll list all 5 children, Jason's 2 children and Cynthia's 3, as equal beneficiaries after she dies, with each getting 20% of what's left when Cynthia dies. But as Jason does his planning, he doesn't like that potential outcome. So at this point, he thinks leaving his IRA to a trust is a good idea, kind of like he did with his $1 million brokerage account. This concept of, after he dies, Cynthia getting the income off of that $3 million IRA, with the principal ultimately going to Jason's 2 kids after Jason and Cynthia die, that sounds like a pretty good idea. But here's the problem with that. When leaving an IRA to a trust for your spouse and then your children, in order to avoid the high trust income tax rates, the trust typically requires the trustee, after Jason dies, to pay Cynthia the greater of the income or the required minimum distribution. And if Cynthia lives long enough after Jason dies, the required minimum distribution, or RMD, rules will require that a large portion of the trust assets be distributed to Cynthia during her lifetime, leaving few trust assets for Jason's children to inherit when Cynthia dies in her 80s or 90s. RMD rules would have required the bulk of the assets to be distributed to Cynthia during her lifetime, and once these distributions are made to Cynthia, they become part of her estate to ultimately go to her 3 children when she later dies. And to compound the problem, if the trust instrument provides that Cynthia has the discretion to make principal distributions to Cynthia for her health, education, maintenance, and support, then Cynthia could distribute more of the IRA to herself in addition to the RMDs, which she will be required to distribute to herself. And there's another problem with naming a trust as a beneficiary of a traditional IRA. Because the RMD rules as they relate to naming trusts as beneficiaries of IRAs are both new and complex, many lawyers, accountants, investment professionals, IRA owners, trust beneficiaries, and the general public have misconceptions regarding the rules that apply when an IRA owner names a trust as a beneficiary. Everybody's confused. The initial knee-jerk reaction that people say when an IRA owner dies and names a trust as a beneficiary is something like, all income taxes must be paid on the IRA within 5 years of the IRA owner's death. But that certainly isn't always the case. So what do you do if you're married, you have an IRA or 401k, you have a second spouse that you want to provide for, and you want ultimately to preserve all or the bulk of that IRA for your children, not your spouse's children, to receive the IRA after you both pass away? Well, because the RMD rules confuse everyone when an IRA is left to a trust, and when you leave an IRA to a trust for your spouse, RMD rules will require distributions of the bulk of the assets, to the surviving, if the surviving spouse lives long enough, leaving little or nothing for your children. You may want to consider leaving a portion of your IRA directly to your spouse and a portion directly to your children. For example, let's say that Jason names Cynthia and his 2 adult children as equal 1/3 primary beneficiaries. So let's talk that one through. By naming each of his 2 children as 1/3 beneficiaries of Jason's $3 million IRA, then upon Jason's death, each of his 2 adult children will have an inherited IRA with roughly $1 million in it. Jason's children do not have to wait another 20 or 30 years for Cynthia to die to inherit from their father. And RMD rules will require that Jason's 2 children take distributions and pay income tax on those distributions from their inherited IRA within 10 years after Jason dies. And with Jason's surviving spouse, Cynthia, as a 1/3 beneficiary of Jason's $3 million IRA, she'll be able to set up her own IRA with that $1 million and take income taxable distributions as she pleases, with RMDs beginning when she's 73. And since Cynthia can treat that $1 million IRA as her own, she can name her children or anyone she wishes as the beneficiary of that IRA. But Jason knows that going into it, and he's okay with that because he left his 2 adult children $2 million of the $3 million IRA. So the end result as it relates to Jason's 2 accounts is as follows. As to Jason's $3 million IRA, his wife Cynthia gets a $1 million IRA to do what she wants to with, and Jason's 2 kids each get a $1 million inherited IRA from which they will have 10 years to take income taxable distributions. And as to Jason's $1 million brokerage account, that, after Jason dies, goes into a trust, since Cynthia will be the income beneficiary for life, and Jason's 2 children will receive the trust principal after both Jason and Cynthia die. So if you're married and have children from a prior marriage, you may need to think twice about naming your estate or naming your revocable living trust or naming your spouse outright as the beneficiary of your traditional IRA. My goal here is to enable you to make a more informed decision based on your goals and based on you having a good enough understanding of the consequences of naming trusts or individuals as beneficiaries of your traditional IRA or traditional 401k. See you next time.